morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Mathew S. Hinton, docket number 2019-097. Representing the appellant, Mathew Hinton, is Sarah Starr. Seated at counsel table with Attorney Starr is Rebecca Turner. Representing the appellee, State of Vermont, is L. Raymond Sun.
Thank you. Counsel?
Thank you.
Good morning.
Good morning, Your Honors.
Morning.
In 7 years, Mr. Hinton will begin serving a 4 to 5 year sentence for escape from furlough, which is an offense that the Vermont Legislature decided in 2019 should only carry an administrative penalty. The state here still argues that Mr. Hinton's sentence cannot be disturbed because at the time of the sentencing hearing, but before the case reached final judgment, the offense of escape from furlough was still a felony in Vermont. The court shouldn't adopt this reasoning because it would lead to disparate results for identical defendants who engage in identical conduct at identical times, but who simply happen to have different sentencing dates in the trial court.
Ms. Starr, there's a statute in place that was cited by the state, 1 VSA section 214. Doesn't that in some way control this case?
And I agree that 1 VSA 214 applies in this case, and I also cite that statute, and I read that statute as being entirely consistent with the common law that gives the benefit of changes in the law to defendants while their case is on direct review. So the legislature has determined, while the case is not final, while it's on direct review, that a lighter penalty should apply and that the previous penalty was too harsh and that the lighter penalty is sufficient. And so the legislative intent should be given on the direct appeal because the lighter penalty should apply in every case in which it can be constitutionally applied.
Is there any legislative, oh, go ahead.
Good. Sorry.
Was there any legislative intent that you're aware of indicating that this should be retroactive?
Well, I think that if the legislative intent was to overrule the common law, then it would need to be very specific on that point.
What are you saying? When you talk about the common law, aren't you talking about the cases that we've, not decisions on statutes like this one, but rather decisions reflecting on other precedent of the court itself? Isn't that what you're talking about?
Cases, but also, also legislative action. Going back to the case of the pirate ship, the schooner Peggy, in 1801, where Justice Marshall, when there was a new treaty passed, declared that if subsequent to the judgment, but before the decision of an appellate court, a law intervenes and positively changes the rule, then that law must be obeyed. I think that the common law going back hundreds of years applies, and this court has been very specific, for example, in the case of TC versus LD, that the common law is changed by statute only if the statute overturns the common law in clear and unambiguous language.
So to follow your argument, because the statute does say that you apply the reduced penalty unless it was imposed before the date of the amendment, do we have to conclude that a sentence is not actually imposed until all appeals are complete?
In this context, that is what it means. The imposed should be read to mean imposed and then reaching final judgment, meaning the direct appeal has been resolved. And I think that there is support for that in the sentencing statute itself. If you look at, for example, the sentence reconsideration statute,
but doesn't there have to be a final judgment in order for there to be an appeal?
Well,
unless it's interlocutory?
Well, there does, but the filing of a timely appeal of an unjust sentence tolls the finality of that decision. And so, for example, if you look at the sentence reconsideration statute in 13 VSA 7042, it talks about any court imposing a sentence, and then in the next clause, it says within 90 days of the imposition of that sentence. And so you have the different constructions of the verb impose. So you have the gerund, and then you have the noun, and it's very like liminal. It's a process where you have within the 90 days, either of the trial court decision, or you get the same relief. If there's a timely appeal and then that appeal is resolved, you can do the same thing at that end. So I think there is a spectrum for imposition of the sentence just written into the sentencing statute itself.
But isn't a sentence imposed at a sentencing hearing automatically in effect unless the court grants a request for a stay of the sentence?
In that sense, it is in effect. I mean, a sentence could be deferred, or it can be, you could have a report date, or it could be, like, for example, Mr. Hinton right now is serving another sentence, so he hasn't started serving the sentence yet. But it is in effect for purposes of filing an appeal. It's not stayed, so he is under sentence. But in terms of, for purposes of looking at changes in the law and reviewing the sentence, which is what is happening now, that can occur on direct appeal. It can occur pursuant to sentence reconsideration, and it can occur after the finality of the appeal, subject to the 90 days.
So you wouldn't say that somebody could come back with a post-conviction relief petition and say, I was convicted on that statute before it was changed, and
I wouldn't, and that it was totally consistent with the common law, that to give the benefit of the changes in the law to defendants while their direct appeal is pending, but not on a collateral attack, is completely consistent with common law.
And on sentence reconsideration, your client, because if you don't prevail here, your client will have an opportunity, I assume, to file a motion for sentence reconsideration?
Yes, within 90 days of this court's decision.
Can you make the same arguments there?
So I was looking at that issue, and the case law suggests that you're not supposed to use post-sentence conduct, but yes, I think you can, because it's still part of this, the way that I read the sentence reconsideration and sentencing statutes is that this is an ongoing kind of review, and that's part of it. So yes, I would say that at sentence reconsideration, they could consider the change in the law. And I think would have to, especially because in this case, what the court emphasized for the major rationale for the sentence was the deterrent effect. And so it would be really difficult to argue that the sentence should be upheld because of a deterrent effect of a law that no longer exists. I don't think a court would be able to kind of suspend its disbelief and say that this would still have a deterrent effect.
You use the term unjust sentence, but is there anything in the sentencing structure here that was done by the trial court that makes it an illegal sentence? And it's fit within the parameters, does it not?
It is in the parameters. I think I was referring to an unjust sentence in terms of that when you're going to appeal, if you receive a sentence that you feel is unjust, you're going to appeal and prevent that sentence from, that judgment from becoming final. And you're going to do that whether or not, you're hoping for an intervening change in the law. So I think that those are however the court decides this case isn't going to prompt more appeals in the event that the legislature might change the law. The court, though, did, while it was not I wouldn't say it was an illegal sentence, the court did tend to seem to believe that there was a chance that Mr. Hinton could get out on parole or furlough, even though all of the evidence and argument showed that that wasn't the case. So that was concerning that the court seemed to think or indicate that that was a possibility when both sides were pretty much unanimous that it wasn't a possibility. So if there's no other questions, I'll reserve the rest of my time.
Okay, that's fine, thanks.
Thank you very much.
Thank you very much. We'll hear from Appellee's counsel now, please.
Thank you, Mr. Chief Justice, and may it please the court. The retroactivity question in this appeal is very simple, very straightforward, and is governed by the plain language of an unambiguous statute, specifically Section 214C. Section 214C, contrary to the argument that appellant's counsel just made, is not consistent with the pre-statutory common law rule, and the court discussed in State versus Matthews that the savings clause, Section 214, the savings clause, was enacted specifically to contravene the common law rule of retroactivity. I'll quote from Matthews now: to avoid such results, so at common law, repeal of a criminal statute abated all prosecutions which had not reached final disposition. To avoid such results, legislatures frequently indicated an intention not to abate pending prosecutions by including in the repealing statute a specific clause. And it goes on. So to the extent that the appellant's position is that we should interpret Section 214C to be consistent with the common law, that is utterly contrary to the purpose of 214C that has been set forth by this court in Matthews.
So in the Sixth Circuit decision in Clark, they apply this concept, because I understand your argument is sentence was imposed when the trial court pronounced sentence. And they say, well, not so fast. It's a more dynamic process, and in fact, it's not final until the Supreme Court says it's final, because that's the function of the appellate court, is to make it final or not if there were errors. What's wrong with that reasoning?
A great deal is wrong with that reasoning. It's first of all, well, where to start? Clark is an aberration. It's been widely criticized, including by the Sixth Circuit itself in a recent decision. Richardson versus United States, the citation is 948 F. 3rd 733. It's a 2020 case. Limited Clark by drawing what in the state submission is a rather thin distinction between imposition and final imposition of a sentence, and interpreting Clark to address finality rather than imposition. I believe Clark and Richardson both.
Clark focused significantly on what they consider to be legislative intent regarding the type of offense. Is there any similar legislative intent that's available in this situation?
I don't believe so, Justice. Clark, I mean, as Your Honor correctly notes, the decision in Clark was based on the Sixth Circuit's sort of divination of the legislative intent behind the statutory amendment that was at issue there, the federal safety valve provision. And it was based on the Sixth Circuit's sense that remedial provision was meant to apply broadly. And the Sixth Circuit found support for that in the legislative history. And I am not aware of any similar support, certainly not in the plain language of the amendment, and I was not able to find any support in the legislative history for a similar.
Why did it repeal the statute criminalizing this conduct? Why did it do that?
It's hard. I suppose I could speculate the legislature just decided that it wasn't appropriate for that to be a felony anymore.
Right, I'm trying to imagine how if the legislature thought it wasn't appropriate to have that be a felony anymore, instead have it be something essentially civil, why wouldn't that apply to pending? What would make us think the legislature thought it was a bad idea to do that, but it was still a good idea to do it for pending cases?
Well, so the legislator has spoken on how situations like that should be addressed, and it has spoken in Section 214C. These are exactly the circumstances that are contemplated by 214C. The legislature is always free, when it passes a statutory amendment, to specify that it is retroactive on direct appeal. There was no such language in the enactment here. So in the absence of any such language to that effect, I think that we need to default to Section 214C, which unambiguously sets forth that unless sentence had already been imposed at the time of, so as long as sentence has not been imposed at the time of the enactment, the enactment is applicable, but if sentence has already been imposed, it is not. So that is the state's position as set forth in the brief, and this is again, a very straightforward case. There's unambiguous statutory language that squarely governs its disposition.
If you win, can the defendant come file a motion for sentence reconsideration or motion to modify the sentence?
That's a good question, Justice. I hadn't considered that in briefing this appeal. I don't think I'm authorized to bind the state as to whether that route of review is waived for timing or other reasons. But I would anticipate that the state would object to it on the merits for largely the same reasons that are set forth in the state's briefing in this appeal. This was an offense when Mr. Hinton committed it. It was a serious offense against the peace and dignity of the state. None of that changes because of subsequent decriminalization.
So the defendant could clearly file such a motion. The question, you're saying probably the position would be the same, that there's no right to change it. Could defendant essentially argue to the court, not so much as a matter of right, but as a matter of exercise of the court's discretion now that defendant's been sentenced quite substantially for something that's no longer a crime?
I can't think of any procedural bar to that argument as I stand here, without prejudice to the state's right to raise any such procedural bar in any further proceeding.
Do you have any comments on the issue of the alleged abuse of discretion by the court in sentencing?
So I think it's clear that the sentence imposed was not an abuse of discretion. It was well within the statutory range. When Mr. Hinton was charged as a habitual offender and was subject to penalties up to and including life imprisonment. Even the penalty for the offense absent the habitual offender enhancement would have been, it was a 5-year felony at the time, and he was sentenced to 4 to 5 years to serve, which is well within the statutory range. Judge Zone very clearly and thoroughly considered the nature and specific circumstances of the offense. He considered the personal characteristics of the defendant. He considered the penological purposes of retribution, deterrence, incapacitation, and rehabilitation. He weighed all those factors carefully and thoroughly. He set forth the reasons for his decision on the record. This is precisely the sort of exercise that we expect Superior Court judges to engage in at sentencing. Nothing that Judge Zone did was reversible error. None of it amounted to, it was certainly not an abuse of discretion under this court's very deferential abuse of discretion standard for reviewing the substance of criminal sentences.
When the sentencing hearing occurred, which was in March of 2018, and the statute went into effect on July 2018, was there any awareness during this process that this was being considered by the Vermont Legislature to decriminalize the escape from furlough? And was it ever brought up in front of with the trial judge?
I'm not sure, Justice. So my review of I hadn't been looking for that in my review of the transcript, so I'm not able to make a firm representation to this court about that. But in any event, I don't think it would be relevant. Regardless of whether Judge Zone knew or did not know about the sort of pending legislation, his weighing of the appropriate sentencing factors was well within his broad sentencing discretion in this case.
I'm curious, do you happen to know when the legislation was passed? I know the effective date was July 1, which is sort of the default.
I think it was a little bit before then. I think it was maybe a month or I think a little less than 2 months before then. Again, I'm not able to make a firm representation to this court, but I think it was sometime in that time frame. It was after Mr. Hinton was sentenced. If there are no further questions, the state will rest on its briefs.
All right, fine. Thank you very much. Does the appellant have time?
Appellant has 5 minutes and 49 seconds remaining.
Okey-doke. I'm sorry?
She waived.
Oh, okay. All right. Thanks a lot.
Next hearing for the court is scheduled for 1:30 this afternoon. The Q&A will follow a brief recess for the judges.